the court today. A very splintered opinion, but what it came down to, 6 on one side, 2 on the other. Justice Kagan not taking part, having recused from being involved, we think, as Solicitor General. Steve, what do you make of the opinion and what people should know about what it really is about?
Right. I mean, it did not get into as much of the specifics of the policy debate over affirmative action so much as it helped decide who should be in a position to help make these decisions. And basically, it said voters in a particular state, if they want to, should have a say on these things. And I think Justice Scalia made that argument, I think, quite forcefully, as he often does. It has interesting sort of legal repercussions in the short term, but I don't think it solves the problem. I think this is going to be a battle in the courts, certainly for a long time to come. The politics of this, I think, are also very interesting. If you look back at what the original proposition, the Michigan Civil Rights Initiative, said, it is really not a controversial statement drawn from the language of the 1964 Civil Rights Act. It says, in relevant part, the state shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting. It's pretty simple language, and there's a reason it won 58 to 42. And what struck me about Justice Sotomayor in her rant today was she was in effect, I think, calling the 58% who voted in favor of this, drawn again from the 1964 Civil Rights Act, racists, or suggesting that they have racist thoughts. I thought it was a disgraceful dissent from her.
She was very passionate, and as we talked about, when they read from the bench a little bit of the majority opinion, just sort of synthesizing the entire opinion, sometimes the dissent will read too, and today one, by my clock, Justice Sotomayor read for 15, maybe 20 minutes, very passionate in reading a large section of her dissent today.
I don't think there's any question that there's a deep grievance here, and it's one that's historical in nature, Shannon, and it has to do, in this case, given that it's really not about affirmative action per se, but about the right of voters to make a decision. As Justice Kennedy, who's now the key vote on all these racial issues, said, it really is about allowing the voters to make a decision on a very difficult, complex issue and not doubting their maturity or their intent. It's not saying, oh yeah, well, these are mostly white voters, are going to behave in this way. So they have a right to make this decision, he said. Now, this is contrary to what we've seen in the past, where the court has said you can't ban, for example, school busing. You can't say, oh, we're not going to have school busing. You can't say we're not going to have a ban on housing discrimination because you don't like having blacks live next door. So this is a very distinct decision in that way, in which it says we are trusting the voters of Michigan and any other state to deal with this very complex issue. What you heard from Sotomayor in that impassioned, long, as you point out, dissent, unusual for those of you who don't know that she would do this, was to say that, you know what, the High Court has a duty to protect the constitutional right of the minority, whether it's a religious minority, a racial minority, an ethnic minority, and you can't just allow the majority of voters to run roughshod over the rights of that group. And she feels that in this case, that is what has happened. And she feels that when you hear from Justice Roberts, the Chief Justice, that, we need more color blindness in this society, that he is operating in a way that closes his eyes. I think she used the language like that. If you really want to deal with race, you have to speak candidly, she said, and keep your eyes wide open, and not be reduced to simplistic formulas like, oh, guess what, if you want to end discrimination, which is basically what he said a few years ago. And
in her lengthy dissent, she outlined a number of cases where she felt it illustrated there's still a big problem with race issues in this country, and saying it's not that simple.
Right.
And she got into a heated back and forth with Justice Scalia in these writings, and clearly, very passionate.
Yes, but not convincing in any way. This decision is perfectly consistent with a contrary decision the court made 11 years ago in Michigan, where there was a case to abolish affirmative action in admission to the University of Michigan Law School. The court said that we are not going to strike it down. We're not going to have 9 rogues decide that this cannot be implemented. But what it implied was it would allow the people in a democracy to decide that. The people responded exactly as suggested implicitly in that decision when 3 years later they had a referendum that would abolish affirmative action. 11 years later, with now a case brought by the left and not the right, the left is trying to institutionalize affirmative action to make it impossible for any legislature or any referendum ever to abolish it ever in the history of the country. Essentially to say that it's an intrinsic part of the Constitution, racial preferences are here forever. An outrageous proposition that was rejected by the court, and it said we're not going to rule that it's intrinsically in the Constitution, just as 11 years ago we didn't want to rule that it's not allowed. We leave the decision of affirmative action up to the people, which is exactly the way you want to do it in a diverse democracy with a troubled history. Let each region, let each state decide on its own, exactly as was happening with abortion until the court stepped in and prevented the evolution. Ruth Bader Ginsburg, who actually was on the dissent in this opinion, said years ago that the Roe decision with abortion prevented the natural evolution and reform on abortion and prevented a stable settlement of the issue. What happened today on affirmative action, there's a towering decision that will allow now a stable settlement as the country, very complex and diverse, works it out state by state, exactly as you want to do it in a democracy.
And as Justice Kennedy pointed out, and we've talked about numerous times here, this wasn't going to the merits or substance of affirmative action. It was about the voters' ability to decide.
It's that we on high will not decide yes, we will not decide no. We will simply say, in a democracy, it's the people who decide.
But I think you have to protect the individual, and I think that is what you're hearing from Sotomayor, and I think there's a concern here. It's not just the individual. In this case, they're racial minorities. And you have to understand...
Like Asian American students who don't...
I'm sorry, did you...
Like Asian American students who everyone knows...
Correct. I think that's the strongest point, Charles.
Are discriminated against because of
I think that's your strongest point, because I think there is more and more of a racial mix in this country, and it's harder to decide, well, who isn't deserving in this racial mix. But let me just say that if you're on the university campus, you don't see the voters of Michigan voting to do away with legacies or do away with preferences for athletes or the children of the rich. All of these people get into the schools at a disproportionate rate. They're not addressing that. The one thing they come to is race, and I think that's why Sotomayor and so many are concerned that what you're seeing here is a racial group being run over.
And this also, just to point out, as you noted from reading the language, I mean, it also applies to gender. So race and gender are the two criteria that we're talking about with this decision.
Right. What Juan said twice, I think this was very actually, I'm not sure if you did it on purpose, but in describing what Justice Sotomayor said, you said twice, she feels. She feels this. She feels this. That's exactly right. This was a decision written by somebody who was writing about emotion. It was President Obama's empathy standard. That's what he had said he was looking for when he nominated her. That's what I think he got. But in terms of what she argued, it was intellectual hogwash.
Wait. But you can. When I say feel, when I say feel, Steve, what I'm saying is she made a very strong argument that I believe has an intellectual basis. I'm not suggesting that she was just engaged in a spewing her emotions. I think there is something to be said for protecting the rights of individuals.
If there was a coherent argument in there, I failed to find it.
Okay. We're going to leave.